Stan Lapidus is a pioneer in the medical diagnostic industry. As an inventor and entrepreneur, he's founded CITIC, Exact Sciences, Helicos, and SynapDX. And he sits on the board of many, many more biotech companies. Join us for a discussion about medical inventions on Intellectual Property Conversations with Makena.
My approach to being an inventor is first comes the problem, and as an engineer who loiters at the nexus of medicine, engineering, and biology, I view myself as a guy with a tool bag in pursuit of unsolved problems or poorly solved problems or problems people thought were solved but in fact weren't solved at all. And when I run across something like that, I then start thinking about, using my limited tools, how to do it better. And so for me, invention comes from the process of identifying problems. There are different ways to do this. In medicine, one way to do it is to first understand what people die from and what causes human misery. And then it comes from just reading the medical peer-reviewed literature and seeing if one can find holes, as it were, in thinking. And, most of the time, the ideas go nowhere. Every once in a while, every decade, or even longer, really, for me, I do have an aha moment and start companies around those ideas. So the invention is intimately linked to a process of trying to identify unsolved problems. The nice thing about doing it in medicine is it requires sufficient expertise that it's not available to the casual inventor. There's an impenetrable language you have to learn how to penetrate, concepts that you have to learn. And every time I've tried to compete where there are already established competitors that are pretty smart, I stub my toe. And it's really finding problems that have been overlooked that have resulted in the things I've worked on that have turned out well.
That's really interesting. Especially approaching it from a background where people might, as you say, already be established in the field and trying to see what they haven't seen, which of course you can only see from that perspective of a newcomer with your toolbox and gaining new tools on the way.
That's right. And for me, it's the great fun of it. So I'm not a millennial, you get that, right? I'm 70. And there's a cultural trope, I guess you'd call it, of work is supposed to be fun, and fun comes from having football tables and things like that are holdovers, in my view, from childhood. And for me, work is the intellectual challenge. It's the reading, it's the problem solving, it's rapid dialogue with smart people. For me, that's the most fun in life. That informs my worldview. What do people die from? They die from heart disease, stroke, cancer, diabetes, sort of in that order. Chronic obstructive pulmonary disease is one of the top 4 as well. And much of my efforts have been focused, actually in my case, mostly have been early detection of cancer for those cancers for which early detection saves lives. So I'm not the guy who's going to show that a pap smear saves lives. I'm the guy that can make a better pap smear. And if you already believe pap smear saves lives, then you'd also believe that the gizmos my teams and I have worked on will save more lives. Same thing with early detection of colon cancer. It took literally decades to show that removing polyps before they became cancer prevented cancer. That was something that sounds obvious in retrospect, but was not obvious at all. Not my discovery. My discoveries or inventions were how to find polyps without a colonoscopy accurately. I don't do the medicine, I don't do the epidemiology, but I try to bring to bear my skill as a gizmologist to problems that have been defined and are crying out for a solution. And others say, oh no, we've solved it. Colonoscopy is a great solution for early detection of colon cancer. Well, it's not really a great solution because 60% of people don't get it because it's a daunting procedure that requires a horrible bowel prep and lose a day of work. You have to have someone accompany you because you're sedated. Even in saying, I have an Uber driver who's going to pick me up, not good enough. You have to bring someone with you who has to be presented, who will take you to and from the colonoscopy. Well, that's not the same as getting a blood test, or in the case of the exact test, taking a poop at home in a bucket and shipping the bucket in. And that's the way I think about these problems and has been my approach to invention.
A key thing that you're pointing out is joining things that already have their own momentum, that in that way facilitates both your gizmology, but also allows you in turn to help that momentum accelerate forward through your contributions.
That's right. That's exactly right.
Something I'm curious about on that point is, what does it mean to you to have a good solution? We've kind of seen this landscape of imperfect solutions where we made great progress, but it isn't actually an ideal world.
Particularly in medicine, all solutions are imperfect. Every diagnostic test has inaccuracies, every treatment has side effects. Patients still die from medical errors despite the best attempts of people, men and women of goodwill, to control medical errors. But what it means to me, every once in a while, and more recently than in earlier years, I run across someone who's had a Cologuard test. People tell me this stuff about the exact test. I had a polyp that was discovered. I never would have gotten a colonoscopy, and maybe this thing saved my life. I'm not a physician. I'm not their physician. But the idea that something I thought of in my basement in 1995, many years later, is continuing to have durable impact on people is very rewarding. Now, that doesn't have anything to do with patents. Patents has to do with business. And as my friend and patent lawyer Tom Myers says, a patent is a business document. It's not like a scientific paper. The idea that patents are improving physical standard of living goes back to the 1780s. Patents are specified in the U.S. Constitution. The reality is, in order to develop medical technology, you have to invest. It's especially expensive compared to developing things that are not medical. And the reason they're expensive is they're highly regulated. The reason they're highly regulated is because mistakes can have grave consequences. These things take hundreds of millions of dollars to bring to market, from concept to commercial success. You need to be able to tell an investor, look, you're going to invest hundreds of millions of dollars for a market that I believe exists, but you don't know. But we finally get there, at least we'll have some enduring patent protection for a period of time, so others just can't copy and step right in. So I would say, in medicine in particular, patents are an essential component of fundraising. Fundraising is an essential component of developing technology, which makes our lives longer and more pain-free. So to me, the patent system is at the heart of the progress we've made as a society. The amount of investment in healthcare companies on the part of the private sector dwarfs by orders of magnitude the spending that the government does through the National Institutes of Health, for example. That investment would go away if there were no ability to patent and protect.
It's very clear how intellectual property can enable and support your projects and the healthcare system as a whole through innovation. So how has the pursuit of patents for your medical devices and technologies shaped your process of research and development? How has looking forward to that fundraising aspect influenced the early stages of invention, if at all?
It's actually a great question, and the answer is hugely. We'll talk about a different industry. If you wanted to get into the bicycle business, you'd say, huge market, actually a growing market. It's a market that's over 120, 130 years old now. Mass production of bicycles with rubber tires. There's no patent protection in the bicycle business. So what you're left with is what? Let's say you're a passionate cyclist and you believe that we'd all benefit by riding bicycles more and using automobiles less. To open a factory, you need $20 million. How'd you go about and do that? What are the levers that you have as a person who cares passionately about bicycling and wants to be in that business?
You probably have to appeal to people for fundraising within the cause itself.
That's right. You have reasons other than this is surely going to be a profit-making business because you've got a zillion competitors globally from small to large. You might have a design idea, a technology that makes your bicycle lighter weight, for example. And if that's true, you'd work really hard to patent it. What's very hot right now, in which there is a lot of intellectual property, are electrical bikes that are either electrically assisted or you just, rotate the throttle and go. So there's a lot of fancy motor technology and battery technology. So in an otherwise staid and undifferentiated business, here's a niche which is very hot because of the opportunity to differentiate yourself. And you can raise money for an electric bicycle company. If you had, for example, a battery that would last twice as long, if you had a motor that was more efficient or could put out more power for a given size or had a better power to weight ratio, those are things that would say to investors, this has a competitive advantage this person, if he or she has appropriate business skills, can build the company, and we know that it's a good investment because it's protected. Well, in medicine, that's to the nth degree because it's so long to go from concept to production. We all start off with limited means, and it's actually the concentration of capital that allows the kind of investments, that allows the kinds of breakthroughs that have caused the doubling of the lifespan of mankind in the last 120 years. To me, there's a direct connection.
One thing that is extremely important about what you just mentioned is that concept of time from the initial idea to production. Having spoken to some other people, I've gotten the understanding that one of the most important things with patent is in the timing itself to actually retain that exclusionary right once you are actually at a stage where you're selling, and it's not that you've spent 20 years developing it or 19 years and then you have 1 year to gain everything back with sales.
What really happens is as you work on something, you have more and more ideas to make it better. So you might start off with one patent, but by the time you're done, you might literally have 100, each with a different filing date. And some of the best ideas might happen in the last years of development, so that you actually extend patent life by extending the original inventive ideas.
Right. So developing patent families in order to build off that time and expand it.
This is very much, on the one hand, part of the detail of patent strategy, and on the other hand, back to the world of fundraising and raising enough money to do these things, is an expectation. A question I get is, well, what patents do you have, and what patents do you expect to get? And I don't know what patents I expect to get, but the answer is, don't worry, we'll think of plenty of ideas, and we always do.
From a practical perspective, I assume that if they're asking you that question is because there's an interest in investing, and so there is a supply of funds. But as you build a patent family, I imagine that with each additional patent that you might need to then take to an international scale, that process just gets more and more expensive.
It does, and I have no good solutions for it. I think that part of the system is broken. There should be a single international patent system. The idea that if you've got your U.S. patent or within a year of filing it, you need to file in Europe and Japan and China and other countries in which you might expect people will use your invention. It's crazy. It's hugely expensive, and it's a boon for lawyers for no added value. I don't disrespect lawyers, but a legal system that just moves paper without adding intellectual content isn't great. And I think the U.S. Patent Office has been a huge driver of innovation in the U.S. The international patent system, broken.
Of course, I don't expect you to have an expertise in this area, but do you have any thoughts on what is standing in the way of an international patent system?
I think it's self-interest on a zillion parties who are happy with things the way they are. I think that's it. There's no agent for saying we need to sweep away this very fragmented international patent system and replace it with something that costs no more than a filing in your home country. I filed my first patent in Japan, I think it was in 1984 or 5, something like that, many years ago. And it wasn't in medicine, it was in industrial automation. And I remember I had to go to a Japanese patent lawyer. They charged thousands of dollars to translate the American English patent into Japanese. This was in the days before there were word processors in Japan. So to print this document to send to the patent office required using something between a Gutenberg printing press and a typewriter. It had 1,920 slugs of kanji characters. You clip this kanji character into a clip, hit this thing with your right hand like a hammer. It would fling the character against the paper, and you do it again because typewriters were too unwieldy. And the whole process was designed to enrich people along the way who contributed no value to the business of protecting intellectual property. The same applies for Japanese inventors, who wish to patent in the U.S. and Europe. They face endless roadblocks.
Out of curiosity, in terms of patent enforcement, have you had any experiences both within the nation or outside? I imagine it must be so difficult to enforce a patent in a land that's not yours.
Or even in your own country.
Yeah.
Patent enforcement is very expensive and the outcome is uncertain. I've been involved in patent litigation a number of times, not many, and it's always unpleasant. The deposition process is unpleasant. It's highly adversarial. The discovery processes, send us thousands of emails. Any patent prosecution or patent defense costs millions, single-digit millions, and for high-stakes things for which the picture is unclear, it can be even more than that. So let's say that I believe that you wrongly copied an invention of mine. I would sue you. You would sue back. And you would say the patent is invalid, this prior art, all the inventors weren't named. You do everything to say my patent was fraudulent, and I would do everything to say that you were an unprincipled, unethical person, and we would each spend millions of dollars to prove our point. Patents get invalidated all the time for reasons good and not good. It has to do with the quality of the litigators, and the being a principal in these things isn't a lot of fun. It's not a smooth process. The opponent's attorneys work to make you look stupid and venal and willfully ignorant and all these things. My experience has been they've worked out, but many people have had experiences where they don't. The patents are blown up and you're made to look like a jerk. I think it's less of a process with copyright infringement. You either did or you didn't infringe the copyright. If your words are that person's words, that's infringement. End of story. But for inventions, the game's now to try to claim as broadly as you can in order to block other approaches. And then others say, oh, no, your claims are too broad. And the patent office often does that. People who work in the patent office are actually quite smart and quite dedicated. My interactions have always been quite good with individual examiners and their supervisors and stuff. They work in fields of knowledge, and they're very knowledgeable about both the scientific literature and the patent literature, and they're very good at searching. So the game is, as an inventor has an invention, the inventor's lawyer comes up with a broad interpretation of the invention. The patent office knocks it down, and you go back and forth, and you compromise. It takes years to get a patent that's not trivial. Streamlining that process is something that could be done better, but I don't have any ideas on how to do it better, except fund the patent office with more money, because it's an important part of the engine that fuels the physical world.
Actually, I had the pleasure of speaking to Mr. Myers yesterday.
Oh, good.
Yeah,
good.
It was great.
Yeah, he's been doing my patents on and off, mostly on, for the better part of the last 25 years, something like that.
Wow. About the alternative to litigation within enforcement is in cross-licensing, or simply licensing the patent, but it's not necessarily something all companies look for. As an entrepreneur yourself in different life science businesses, how attractive do you see the concept of licensing as you're building your different technologies?
It's very important. It's very situationally dependent. You could say, look, let me license something and get 2% of the other guy's business while the other guy's going to compete with me is a better choice than having the other guy compete with me, and I've got to mount a multi-million-dollar patent infringement case which may take 10 years to work its way through the courts and which I might ultimately lose. And then further, if the other guy has something I want and you do a cross-license, I'll pay you 2%, you pay me 3%, because what you've got is more valuable maybe than what I'm giving you. But cross-licensing is very valuable, and there's also something called patent pooling. When transistors and transistorized circuits were invented and radio and television were invented, it started with all these companies suing each other, and they realized soon enough that the best possible outcome was to put all their patents in a pool. You had to contribute something in order to take other patents out. But once you were in the pool, you basically were able to manufacture your television or radio or hi-fi without royalties, paid like a one-time fee or something. But patent pooling minimized what was becoming a very messy litigation space.
Mm-hmm. Something I wanted to ask you earlier that stayed on my mind is when you are in the process of scouting a problem that people have that you want to address, what is the smallest unit of an idea you need before you say, here's business potential, this is something I want to get a patent on, and this is something I want to move forward and not just go back to the scratch board and try something else?
So that's an excellent question. As I mentioned to you, I approach my life as an inventor by starting with the question of what's an interesting problem others have overlooked. And when I don't do that, I often find myself in an unhappy spot. So others have to have overlooked it. It has to be big. And big has a metric. So in my world, where I think of it takes $100 million to get a company public, investment money, before the investors can get their money out, they have to put $100 million in or more. Let's say it's $100 million. Then I have to be able to look them in the eye and say, I can return you $1 billion for your $100 million investment. Because the investment's risky. There are a lot of chances it won't work, that it'll take longer, and the $100 million is really $300 million. So I look for markets that can be quantified as representing a greater than $1 billion a year opportunity. I don't always do that. I worked in autism for some years trying to develop a blood test for early detection of autism. It's a $1 billion market if you really stretch what the definition of the market is, but it was a field with no competition. We ultimately were technically unsuccessful, but it was an important problem in the sense that autism is a devastating disorder, and there's so little that can be done other than early detection and earlier behavior intervention, but nobody had solved the problem of early detection, so I thought I'd give it a shot. Long story short, 10 times more annual sales than the amount of capital that cumulatively needs to be invested is a good rule of thumb. We can unpack this a little bit. You can raise money if the markets are large, as measured by the number of lives affected, by the cost of not intervening in a disorder, and that's why the early detection of cancer is so attractive. Everyone is at risk for cancer. You may know the numbers. 1 out of 2 men and 1 out of 3 women will be diagnosed with cancer in their lifetimes. 1 out of 4 of us will die from cancer. Those are the widely quoted numbers. If that early detection can prevent death or prevent significant morbidity, is a big deal. The tests are relatively inexpensive, but the market is huge. There are other areas of medicine which are controversial, but rare diseases for which drug companies are trying to cross the $1 million barrier. And why? Because there's a handful of people with those disorders. Once they've gone through all the clinical trials and all the development and invested hundreds of millions of dollars, the return can be high. Insurers tend to pay for it because overall it's a small fraction of what the claims they pay out on rare diseases, even if the drugs are expensive, especially if they can make a patient more mobile, less subject to other diseases, all those things. But that's controversial. Drug companies are exploring the corners of the envelope and how much they can charge. Healthcare is a business in the sense that you can't do healthcare unless you've got investors, in my case, or you can't do healthcare if the cost of doing it is more than the income from doing it. But the crisp answer to your question is look for markets where the annual sales are 10 times larger than the amount of capital you believe is needed to get there.
When you find that idea that has that tenfold return, what qualities do you look for in your legal team or your intellectual property lawyer? I know you've been working with Tom for a long time. What qualities do you look in them to be able to really support you?
One is execution. No matter what else a lawyer does, he or she has to move the paper on a timely basis. You have a filing date, never miss a filing date. You have statutory requirements, you have filing fees, all of that needs to just operate seamlessly. I met with Tom 24 years ago, 25 years, whatever, and he was an associate, a young lawyer, quite out of law school. And I described to him what I was working on colon cancer. The idea was still partially formed, yet to form. And he said, oh no, the implications of what you're doing are broader than that. Let's file a claim on that. Let me give you an example here. Before the work we did at Exact, there was a test for determining cancer from stool. It was based on what's called occult blood. So tumors in the colon sometimes bleed. They sporadically bleed. And if traces of that blood find their way into a stool sample and you can detect the blood, you say there's a reasonable chance there's a cancer there. It could also be you ate a bloody cheeseburger. It could also be you're taking aspirin because that aspirin causes intestinal bleeding. But it could be cancer. And the problem was that test was extraordinarily not sensitive. It would miss a lot of cancers for a few reasons. They didn't bleed. You took the stool on the wrong day. There wasn't enough blood. Or the smear of the stool that you sampled as a patient, you would do a poop, go into the toilet with a little spatula, scrape a little bit of stool and smear it onto this card, put the card in an envelope and send it in into the lab. Turns out that the blood isn't everywhere. If you have a tumor near the rectum, you can imagine that the blood is creating a little stripe on the stool as it comes out if the stool is fully formed. If the tumor is in the right side of the colon where the stool is still liquid, the colon mushes it up as the stool becomes hard, and there's these traces of blood everywhere. Well, that turns out to be true. It was a conjecture that I had. We did some experiments. We were able to get some stools from cancer patients, and we saw that if you took serial sections of a stool, the distribution of blood wasn't the same everywhere. Big finding. And we came up with a way that said, before you test the stool, homogenize it. So the exact test is you poop into a cup that fits onto your toilet, you ship the cup in, the company homogenizes the sample, and now every little tiny aliquot, every little sample that you withdraw is the same as every other one and has the same likelihood of showing evidence of an abnormality. That invention, the reduction to practice, was my colleague Walker Sloan and I. We went to the hardware store, we bought a paint can shaker, we made like artificial stools out of bananas and oatmeal, and we did methods for homogenizing the stool, and we bought hex nuts, these big stainless steel nuts that you would use on a screw. We put them in there with the stool, we turned the paint can shaker on and homogenized the stool very well. So we wrote up a patent. We went to a firm that didn't have good patent lawyers, and the lawyer wrote up a method to homogenize stool comprising the method of using a paint can shaker and 6 hex nuts. And that's so specific so that if you used 7 hex nuts, you wouldn't be infringing. If you didn't use a paint can shaker but used a centrifuge, you wouldn't be infringing. One of my investors actually said, Stan, you're headed in a bad direction here. Go find a good patent lawyer. And he recommended Tom's boss. I met Tom, and Tom generalized what we did and got a patent that has withstood attack, any method for homogenizing stool to get a diagnostically accurate sample. Well, that turns out to be foundational patents for Exact because it ensures that our accuracy will always be higher than the accuracy of people who don't homogenize the sample, regardless of the homogenization method. I had that discussion with Tom in 96, and by the end of the hour I spent with him, I knew he was my guy. 95, 96, whatever. That meeting was definitive.
That's an amazing story.
And so that's the value added that a great patent process, it's a funny term, a patent prosecutor is the person who writes the patent, not the person who litigates it. It's a combination of some biology, right, an idea, an engineering idea, and then Tom's ability to understand the true implications of what I was describing to him.
That foresight of what that can turn into and what that can mean, and what problems can come in the way.
This is a good point. When the patent examiner at the patent office, you can imagine that person would have looked very hard in the literature to see if anybody had ever homogenized a stool sample before in order to do a diagnostic test. And the answer is no. And had the answer been there was even one report of that, we'd have to significantly modify our claims because there would have been prior art. So it turned out that we had landed in a new area, and until our work, the only stool tests were for bacteria and parasite, protozoa and stuff presence, and that's automatically homogenized because it's present throughout the entire gut. So people never thought about homogenization. The assumption was any bit of stool is as good as any other, just like any drop of blood is as good as any other. But for cancer, in the colon, it's not true.
So it also requires a little bit of that ability to search into the history of invention itself.
That's right. And I mentioned to you, I probably read less than I used to, but I was just like a voracious reader of the scientific literature. This was before you could get journal articles online, so I'd go down to the library at MIT physically, and I would sit for hours and hours, and I'd go to the stacks and read something and pull a reference and go to the stacks, and that's a competitive advantage. The patience and the feeling, you could either think of that as extraordinarily tedious or a great intellectual hunt. It's both. Actually, it is tedious, but it's also the thrill of discovery and seeing, aha, nobody's reported on this before. I'm an engineer. I'm not trained in medicine. It required acquiring the vocabulary and learning the concepts. A very narrow medical education in a very specific field was also great fun to acquire. And that joy of discovery and joy of learning was something that has always characterized me when I'm in invention mode. And I imagine it's true of others as well.
My favorite part of a good book is definitely the references, because then it's how you see how it came to life and how it got built up. It turns into this whole web of knowledge.
So one likes to think that as an inventor, it's a solo act and I did this, and it's true, but one should never forget that it's also based on the work of others that have come before one, and that's embodied in the references. Hunting through references to construct a more accurate picture of the truth is great fun and very valuable.
As we approach the end of the hour, I was hoping I could ask you a few more questions, starting more on the healthcare genomic side. I'm not sure if you have a preference of one to tackle.
Let me start with something that I found when I was starting Exact. Again, I'm an outsider, so I didn't have prejudices about gene patenting and stuff, but I found the idea of patenting genes as morally offensive. And it's not an invention, it's nature. Discovering is not what the patent office is about. The patent office is about invention. Discovering what a gene does or where a gene is in the genome. That's not something you did. It's something that nature did. In the 1990s, there was really a land grab for patenting genes, and there were companies that were formed because gene patenting was allowed until it was turned over later. There were companies that were formed solely for the purpose of finding genes, even if their function wasn't entirely clear, and getting patents on them. So if you wanted to do a diagnostic test based on multiple genes, you have to go license lots of things. And again, they're not inventions. So I was really offended by it. I was pleased when the Supreme Court basically finally tossed out gene patents. And in the years that have passed, I would say that the disaster that some predicted did not happen. The disaster being the loss of incentives to do genetic research, because the techniques, the methods, and the combination of those methods is still patentable, as it should be, and I think has led to a period of greater intellectual ferment than before. The Supreme Court did the right thing by differentiating between discoveries and inventions, in my view.
So what I hear is that the role of intellectual property is really around genomic information and not in genomic information itself.
That's great. How to use genomic information in novel ways? Very important. But things that are made by nature, by the hand of God, makes no sense to patent that. It's just not an invention. And again, the patent law is about invention, not discoveries. People who make discoveries, that's the scientific literature, and invention is different. The motivations for scientists in that sense, for discoverers, is different.
Many thanks to Mr. Lapidus for his time and insights. If you enjoyed this interview, please like, subscribe, and share for more intellectual property conversations with Makena. TTYL.